Hi friends, I am Dr. Pratap Singh Rathod. I have done MD in Forensic Medicine. In today's videos, we will discuss about criminal responsibility of mental illness. So, criminal responsibility usually question arises when a person has done some certain crime like a murder or a theft or assault, and he wants to plead that he is guilty, he is mentally ill. So, criminal responsibility question arises when the person may be unfit to plead. So if the person is already a mental illness, he may have done some crime, but he may not be able to plead in the court of law that he is mentally ill. So in that cases, if he is unable to plead, when he can't understand the nature of proceedings of the court from distinction between a plea of guilty or not guilty. So in that case, the person is considered to be unfit to plead, and usually the court decides whether the person is of sound mind or not. If soundness of mind is proved, the accused person is found not guilty of any crime he has done and is ordered to kept in psychiatric hospital or suitable place of custody. So usually if the person is proved that he is a mentally ill, and he is usually not kept in prison but he is sent for psychiatric hospital, and he is not is considered as to not guilty. For that this is because a law presumes that every person is sane, that is, a person is of sound mind and accountable for his or her actions. So every person, if he has done criminal act, he is responsible for his any criminal act, that is a mentally fit person, and it has to be proved until it is proved that if the person was unsound mind, because of that he has done crime. The law presumes that every person is sane and he should be pleaded, means he has to be sent to a trial. In that trial only he should be proved that he is mentally ill. Then only the law will send the person to will be held not be kept as not guilty. Before that, the law will not presume that the person is unfit, is mentally ill, and he should not be punished. So every person has to be sent for trial in the court. Then only it can be proved whether the person was mentally ill or not at the time of doing the crime. The law also presumes that for every criminal act, there must be a criminal intent or a mind, that is called mens rea, motivating the person for that purpose. So mens rea is guilty state of mind. It means every person, when he does a crime, there is some guilt in his mind, and he has some intention of doing that crime. Mainly in the sane person or fit person. If the person is unfit or mentally ill, he doesn't have any criminal intent and he doesn't has any motivation of doing the crime. And he can, if the person is mentally fit, he will do actus reus, which means that the actually act he will do at the time of doing the crime. So for this purpose, there is a legal test or certain form of questionnaires or test over there. So legal test in case of mental illness is a test for mentally ill, which precludes responsibility for commission of a crime. So this is a form of a way of knowing whether the person is of guilty mind, that is mens rea, whether guilty mind is present or not. This test provides evidence of presence of mental illness or defect. Also, evidence of presence of mental illness at the time of committing the crime, and also the evidence of disease making the person unable to access his or act as wrong or contrary to law. So this mainly confirms whether the persons there was an intention of doing a crime or not. There should be presence of mental illness. There should be presence of mental illness at the time of doing the act. So at the time of doing the act, in the sense that there may be some conditions where the person may be fit during the period of some certain periods may not be fit, another mentally not fit, or there may be the mental illness may not be so much so that he may understand the law, but even then he has done the law. So it has to be proved. And also there should be some form of disease of making the person to unable to understand what he is doing right or wrong or contrary to law. For that purpose, throughout the world, many form of rules have been come. Most popular is the one is the McNaughton's rule, which is the responsibility of mentally ill, which started with the McNaughton's trial in 1843. So this is the first way where the question arises whether the person of mentally ill should be punished or not. So in this McNaughton's rule, there is a history behind this, and there is a story like of McNaughton. He was Daniel His full name was Daniel McNaughten. He's a 29-year-old Scotsman who was probably suffering from paranoid schizophrenia. He was probably suffering from paranoid schizophrenia since at the time it was not diagnosed. We should assume that he suffered from paranoid schizophrenia. For many he had a delusion that spies sent from Catholic priests with the help of tourists. So tourists is a form of it is a name of the party, the time of which were at the power at the time of in England, were constantly following him, harassing him, and hatching a conspiracy against him. So he had paranoid delusion that someone is they are sending the spies, following him, harassing him, and conspiring against him. So he had constant delusion of that. He also had some form of auditory. He may have probably had auditory hallucination also, with Tories accusing him of crimes of which he said he was not guilty. So he also had auditory hallucination that means he constantly could hear the thoughts, means words or sentences from Tories, the party leader, accusing of crime, which he tells that he was not guilty when then they used to accuse him of crime. So this led to the person to completely go made him to to take action. So therefore, he decided to kill the Tories Prime Minister Sir Robert Peel, making elaborate plans for criminal act. So he did act. He made a formulate the plan to kill the Prime Minister. And on 20th January 1843, he shot Sir Peel's private secretary Edward Drummond in the back, mistaking him for the Prime Minister. So mistaking by mistake, or presuming that person was Prime Minister, he killed the secretary of the Prime Minister, thinking that those that party member are accusing him of crime and harassing him or torturing him or following him. So he has constant paranoia of that. So this led to the trial, and during the trial, he admitted that he was driven to desperation by persecution. So at the time of that, he told that he was constantly in desperation. He did the act because of constant torture. He understood of paranoia and was also of hallucination. In this trial, 10 physicians, 9 for defense and 1 for prosecutions. So 9 for defense and 1 for prosecution found him of unsound mind. So after examining, they found that he was unsound mind and he was found not guilty on grounds of mental illness and was sent to Bethlehem Mental Hospital for life. So for life, he was sent to a psychiatric hospital in grounds that he was mentally unfit or mentally ill. This led to some unprecedented public outcry since the person had committed a crime against a prominent public figure. This led to Queen Victoria to summon House of Lords to special session. The Lord Chancellor, Lord Lyndhurst, put a panel of 14 judges, 5 hypothetical questions designed to clarify the legal position. So this is a history of legal test of McNaughton's, where they formulated 5 form of questionnaires or form of examination to determine whether the person at the time of doing a crime was actually doing the crime because he could not understand the right or wrong, or because of mental illness. The answers which were given at the time of 19 June 1943, came to known as McNaughton's rule. So these 5 hypothetical questions and way of examining the person of a mentally ill person came to be known as McNaughton's rule. The most important of this rule is it states as follows. So in McNaughton's rule, there is one quote which tells the responsibility of mentally ill person, which tells that an accused person is not legally responsible if it is clearly proved that at the time of committing the crime he was suffering from such defect of reason. So wording defect of reason from abnormality of mind, that he did not know the nature and quality of the act he was doing, or that he was doing was wrong. So this is the quote of McNaughton's rule, which tells that accused person is not be held responsible if it is proved that he was suffering from some form of defect of reason, abnormality of mind. Both these words are very important, which has to be elaborated. We'll discuss in next slides. And he did not know the nature of quality of the act, what he was doing, and which was wrong. So based on this rule, in the India, it is interpreted and formulated into by under section 22 of Bharatiya Nyaya Samhita, which states that nothing is an offense which is done by a person who at the time of doing it by reason of unsoundness of mind is incapable of knowing the nature of the act or that he is doing what is wrong or contrary to law. This is the legal law in India which we followed comparing the McNaughton's rule. So this is a comparable comparative to the McNaughton's rule, which is defined as section 22 of BNS, which says that if nothing is offense done by a person who at the time of doing the act, who because of reason of unsoundness mind, because of unsound mind, he is incapable of knowing the nature of the act. So he doesn't know what he is doing, whether it is wrong or contrary to law. So if he doesn't know whether he is doing what he is doing, it is good, bad, or contrary to law, then he should not be responsible for whatever he done. Legally should not be responsible. That is the basic idea of the section 22 BNS. So in McNaughton's rule, there are wordings which has mentioned it's that it shall be clearly proved that whether the person has to be mentally unsound mind, there should be defect of reason should be present and abnormality of mind should be present. So it clearly proved in the sense that unsoundness mind must be directly related to the offense. So the unsound mind has mentioned McNaughton trial. The person has a delusion of persecution, so he was constantly in threat. So in that sense, the unsound mind must related to the offense that he may commit such a way that satisfy the court that the mental abnormality had a direct causative relationship to the offense and that the offense would have not occurred if there was no mental abnormality. So it has to prove that if that mental illness or unsoundness mind was not there, he would have not done the crime. That has to be proved clearly proved in the court of law according to McNaughton's rule. There should be defect reason. Reason should also be there in case of McNaughton's rule. So defective reason is it is necessary to show that the intellectual and cognitive faculties, that is, faculties of accused were so disordered that his reasoning powers or to the facts of actions were not functioning normally. So defective reason means the person reasoning power is lost, his intellectual ability, his cognitive faculties are so disordered that he doesn't know what he is doing and actions are normal or abnormal, he cannot know. That defective reason should also be present in the according to McNaughton's rule. Then abnormality of mind should also be present in McNaughton's rule. So abnormal mind is when the unsoundness of mind defense is used, it must be clearly established that defect of reason resulted from the abnormality of mind. So defective reason and abnormality of mind are related to each other. So abnormality of mind must have related to defect of reason. So abnormality of mind is a legal term. It is not a psychiatric concept. So abnormality of mind is usually discussed in the court of law. So in English law, recognizes the abnormality of mind any disease which is incapable of producing mental dysfunction. When the mental dysfunction is attributable to external factors like alcohol and drugs, this is not considered as abnormality of mind. So abnormality mind should be of mental illness and should not be because of some external factors like drugs or alcohol or anything. Then it will not be considered as abnormality of mind. The rules also states that itself ability of accused distinguish right and wrong with reference to particular crime. So they force the thing that on that of for that purpose for that crime, whether the person had the ability to distinguish between right and wrong for that particular crime. If at the time of commission of a crime, the accused had the capacity to know that his act was wrong, he will be fully responsible even if he was mentally ill and unable to refrain from act of doing at the time. So for that crime, if the person because of if he even if he has mental illness, but he could reason with himself that what he is doing is wrong, then he will be completely be responsible for doing it, right? And he will not be considered as abnormal mind, but even though he may have some mental illness. Now coming to some examples related to criminal responsibility. So if the due to delusion, due to unsoundness of mind, a person thinks that another man is attempting to kill and he kills in self-defense, he is not criminally responsible. So if he thinks that some person is attacking him because of some delusion, and if he kills that person, then he will not be responsible because he acted against the other person in defense. If under the influence of mental delusion due to unsoundness of mind, a person thinks other to be wild animal like a form of hallucination or because of delusion and hallucination, thinking that person is attacking him, a wild animal, and kills him, he will not be responsible because he does not know the physical nature of the act. If under the influence of delusion due to unsoundness mind, a person that thinks that he is a state executioner and he has to execute the victim as a part of his job, then he will also be not responsible. He is exempt from the punishment because he thinks himself to be a state executioner, so he will not be responsible. If under the delusion to unsoundness mind, a person thinks that another person has caused serious injury to his character and fortune and kills him, he becomes responsible because he will be responsible because under the law no one can kill in the person revenge. So in this if because of unsoundness mind he person thinks that some person has caused to lose his fortune or he tries to kill him because of he has met some serious injury because of that person, he cannot take revenge against that person. So because law presumes that no one should be killed because of revenge, then he will be held responsible against according to the law. The defect of McNaughten law is that for deciding that a person is unsound as many only intellectual factors like reasoning power are taken into consideration, but not emotional or volitional factors or delusional beliefs, hallucinations, ability to individuals control the impulses. So in McNaughton's only the intellectual power of reasons are not is considered, and not the emotional factors or delusional part will be is considered. So that is the one of the McNaughton's rule. And the 22 BNS adopted from the McNaughton's rule. So coming to certain crimes where the criminal will be responsible, where they plead that they are mentally ill for certain crimes, like commonest is the murder. So there are many diseases which because of mental illness the person may become a killer. Like there are serial killers maybe become a serial killer because of some psychiatric illness. They may be schizophrenic or they may be psychotic. In that case also they may try to kill other person without any reasoning power. In all these cases medical examination of the person becomes very important. The opinion of medical witness must be based on his own observation, has to observe the patient and he has to drive the opinion. Doctor should obtain detailed history from the accused person from all other sources and then carry out the physical examination and investigations to know, as I mentioned, the person, even if he kills other person, he will not be held responsible if at the time of doing he is not able to understand. So for that purpose, a doctor's duty becomes very important. He has to get detailed examination, physical examination, do certain investigation to know whether the person was sound mind at the time of doing it or not. First of all, he has to take the history of the accused and his family with regard to mental disease, whether the disease is hereditary, some diseases, some mental illnesses are hereditary, and he has to know whether that it was present or not. He has to investigate whether there was any motive of doing the crime. He has to know whether the person had some pre-arrangement of pre-planning were present or absent. Pre-planning indicates that the person has already had he know that he was doing a wrong thing, but even then if he plans those things then he will becomes a responsible person. If there are accomplices are present or not present, accomplice means he has talked with other person for doing his crime or not. The nature of crime, a mentally ill person may kill several persons including his friends and relatives. So what type of crime he has done, whether the crime was related to only the person who thinks he is enemy or it is related to every person who he has met, then indicates that person is of unsound mind. Then conduct of criminal act time at the time of crime and conduct of the criminal act after the crime. A mentally person at the time of crime may not does not try to destroy the evidence. So if the person is of unsound mind, even if he does a crime, he will not obstruct the investigation. He will not try to hide the evidence. He will just be present at the scene of crime. Conduct of criminal after the crime. A mentally ill person may even notify the crime, or he may not even be try to avoid the getting arrested. So that's all should be noted by examiner to prove that whether the person was mentally fit or unsound mind at the time of doing the crime. Section 367 and 377 or 377 of BNSS, that is Bharatiya Nagarik Suraksha Samhita, deals with provisions has to accused person of unsummoned, including fitness to stand trial and subsequent procedures. So from 367 to 379 usually deals with how the accused, if the person is mentally, how to has to be arrested, how to be taken to the court, how the trial should be conducted. Usually, as I mentioned in the uh, uh, that is the law which the admission of the mentally ill, the magistrate usually talks gets when crime is committed, the mentally has to be taken to the magistrate decide whether the person should be admitted in the psychiatric hospital or not. If he is fit for trial, he can be sent for trial. If he is unable to fit for trial, he will be sent to psychiatric hospital, and once he becomes fit, he will be trial will be sent, and will be decided whether the person was sound mind at the time of doing a crime or not. The law considers state of mind only at the time of alleged offense and not generally. This is also very important sentence, that a law only considers that whether at the time of doing the crime whether he was mentally fit or not. Whether afterwards, if he is even a sound mind afterwards, it is not presumed. In generally, it will not be considered only at the time of crime whether it was sound mind or unsound mind. The mental status of response at the time of alleged offense has to be determined. So at the time of crime, what was his mental response has to be determined. Then only can be accused of murder. Mental illness and other pleas. So sometimes person suffering from other form of mental illness may also plead that he is not be responsible, like somnambulism, where the person sleepwalks. It is dissociated consciousness, and crime committed during this is usually not willful or pre-planned. Hence, it is not punishable. So in that case, the person is not pre-motivated doing crime. So if he does any crime, also it will not be responsible. Hypnosis. A hypnotized person cannot be tricked to do immoral or dishonest acts. Hence, so he will not be do any criminal act. Delirium, the commonest form of where the person has some form of hallucination or delusion, like persecution hallucination of auditory hallucination, visual hallucination, or illusion. In this case, the person committed crime if during that period will not be punishable, and he is not held guilty. Drunkenness and criminal responsibility. So there is a subsection for this under section 23 of BNS. BNS section 23 states that a person is not held responsible for any acts amounting to crime under the influence of alcohol or such other intoxicating drugs, provided he was made to consume it without his knowledge. So the law presumes that because of also drunkenness, the usual control over the soundness of mind is lost, so will not be responsible for his crime. But before that, it has to prove that he should have not consumed it with his knowledge. If he has consumed the alcohol, lost his he lost his reasoning power and creative time, then he will be responsible. But without his knowledge, if someone has made him to consume certain intoxicated drugs or alcohol, and because of under the influence of alcohol he had done crime, then he will not be responsible for his act. In case of impulse also, where there is a irresistible force of compelling the person to do certain acts, like kleptomania, where they steal certain objects continuously, they are not held responsible because it is because their disease, they cannot control it, they are not held responsible for that act. Now coming to some legal consideration towards the mental illness. All the mental disorders do not free a person from criminal responsibility for his acts. So even if the person has some mental disorders, that doesn't mean that he is free to do every criminal act and he is not responsible for any act. If the disorders impair the cognitive faculties of the accused, that is, faculty of understanding the nature of his act and its consequences, he is not held for responsible. So only mental illnesses where his cognitive faculties are lost, that means that he cannot understand what he is doing nature is true or do is good or bad, then only he is not held responsible. Other than that, if mental illness says that he can understand about the nature of what act, then he will be held responsible. If the mental illness affects only the emotions and the will, but the cognitive faculties, the person is held responsible. So, if it is related to only to emotions and the will of the person, but he knows that what he is doing is against the law, then he will be held responsible. The law recognizes guilty intent, that is mens rea. As I mentioned, the law presumes that every person is sane and they should have some intent that criminal act should be done, which is the essential part of the crime. Only those persons who are completely incompetent, demented, or wild are considered as or lack the ability to uh, have a guilty intention, then only considered as they are incompetent, only they are not held responsible. The most serious forms of courtroom presentation of psychiatric and psychological evidence is the inherent uncertainty of the field itself. There is often confusion between findings and opinions in individual patients. There are genuine disagreements between experts in common, even in the areas of diagnosis and prognosis. So, mental illness, presuming whether the person has mental illness or whether the person was under the influence mental illness at the time of proving the right. So, this all agreement, disagreement occurs in courtroom, and even the experts may also have different opinion of the same patients. There are often confusions whether the findings and opinions of different individuals correlate or doesn't correlate, and it is only the duty of the court to decide whether the person was fit, mentally fit at the time of doing or not. When medical witness deposes regarding the existence, characters, and extent of mental disease, the judge has to decide whether the disease justifies adequate and ground of unsoundness of mind. As I mentioned, it is a duty of the judge to know whether to decide whether the person was unsound of mind. The question whether in given circumstances a man was sane or mentally sound, unsound is of court to decide, and the duty of doctor is only to know, examine, and give a opinion to the court whether the person was of sound mind at the time of doing the crime or not. There are some other tests also which were formulated in different years, like Durham's rule, which mainly concentrated on the disease of the mental illness. Current's rule, American Law Institute law, which came in 1970, the Bronner's rule 1972. So these are different rules after McNaughton's rule formulated in different type countries. And in India, we usually are mainly consider the 22 BNS, which is for unsound mind. Whether nothing which is defines nothing the offense when it is doing done by the person of unsound mind, and he doesn't know that. And also about 23 BNS, which is related to alcohol or intoxic person. Whether if he didn't did voluntarily drunk and committed a crime, then he will be responsible. But without his knowledge, if he become intoxicated and done crime, he will be held responsible. So these two laws are the criminal responsibility are defined under that. They're and they are mainly based on the McNaughton's rule. The other rule also are present. These are my references. Thank you.